The key turned once and the engine answered. A quiet driveway. A federal seal on the license plate. A mistake that would unravel a life. By sunrise, a car theft had become a federal case, a racial reckoning, and a sentence so severe, it stunned the courtroom into silence. This isn't just about a stolen vehicle. It's about power misread, bias exposed, and the moment ordinary crime collided with the full gravity of the law of justice, accountability, and the fragile line between authority and arrogance matter to you. Stay with this one. Listen closely. The truth here doesn't shout, it settles, heavy and unavoidable. Long after the verdict is read, the morning didn't arrive with drama. It came softly, thin sunlight, spilling across manicured lawns, sprinklers clicking on a timer, the distant bark of a dog 2 houses down, the kind of suburban quiet that convinces people nothing important ever happens here. The judge stood in her driveway with her phone in one hand and her car keys in the other. Black sedan, government issued, clean, unremarkable by design. The federal seal on the license plate was subtle, meant to be seen only by those who knew what to look for. The engine hadn't even started yet. Across the street, a man slowed his walk. Middle-aged, ball cap pulled low, his eyes fixed not on the car, but on her. He paused, then turned fully toward the driveway as if drawn by something out of place. "You can't take that," he said. The words weren't loud. They didn't need to be. They landed with the confidence of certainty. She looked up, momentarily unsure he was speaking to her. "Excuse me, that's not your car." He stepped closer now, scanning the vehicle, already narrating his conclusion. "I've seen this neighborhood. I know who lives here." The judge kept her posture steady. Years on the bench had taught her the power of stillness. "Sir," she said calmly, "this is my vehicle." He shook his head. A short, dismissive movement. "No, I'm calling this in." She watched him pull out his phone, not with panic, with recognition. This moment had a shape she'd seen before, just from the other side of the courtroom. She spoke again evenly. "I am a federal judge. This car is assigned to me." The word judge didn't slow him. If anything, it hardened something behind his eyes. "Anyone can say that," he replied. "People steal cars like this all the time." A neighbor's curtain shifted. Another door opened briefly, then closed. The neighborhood noticed, but no one intervened. Silence has a way of disguising itself as neutrality. The judge reached into her bag and produced her identification, not theatrically, not defensively. She held it out, arm steady. He didn't look. Instead, he moved past her. The click of the door unlocking was sharp in the still air. The sound sliced through the morning like a line crossed. "Sir," she said, her voice firmer now, "do not touch that vehicle." He opened the driver's door, sat down, adjusted the seat. In that moment, it stopped being an argument. It became an act. She stepped back, not in fear, but in calculation. Federal policy was clear: do not escalate. Observe. Document. Preserve. The engine turned over. Somewhere, a 911 call connected. The timestamp logged automatically 8:14 a.m. local jurisdiction. Vehicle theft in progress. The dispatcher typed fast, unaware the report had already slipped beyond the boundaries of ordinary law. The man looked at her one last time through the windshield. There was no triumph in his expression, just certainty. The kind that doesn't question itself. He drove away. The driveway felt suddenly larger, emptier. The judge stood alone, phone pressed to her ear now, giving precise details with practiced clarity: make, model, direction of travel. Her voice never shook. Across town, a patrol unit was assigned. Standard response. No sirens yet. Just procedure. What no one on that channel realized, what hadn't yet surfaced in any report, was that federal protections had already been breached. That this wasn't just property, it was jurisdiction, authority, a crime layered with assumption and amplified by consequence. The judge ended the call and stood still for a moment longer. She didn't chase, didn't shout. She watched the empty street where the car had vanished, understanding exactly what had been set in motion. This wasn't about a driveway anymore. It was about what happens when bias mistakes itself for vigilance and collides with the full weight of the law. The morning returned to its quiet. Sprinklers kept clicking. A delivery truck passed by. To anyone watching from behind glass, it looked like nothing at all had happened. But somewhere between that turning key and the disappearing taillights, the case had already outgrown the street it began on, and it was no longer local. By the time the car disappeared around the corner, the boundaries of ordinary law enforcement had already blurred. What started as a local property dispute had triggered a cascade that would draw on federal agents with jurisdiction, training, and authority that far exceeded the man's imagination. In a matter of hours, the neighborhood's quiet streets became a nexus for procedural precision, where every detail mattered, and every misstep could amplify consequences beyond comprehension. Agents arrived with measured calm, unhurried but deliberate, as if their presence alone shifted the atmosphere. The driveway, now vacant, held an echo of the theft, the lingering scent of gasoline, a faint scuff on the pavement, the impression of intent that only trained eyes could read. Each officer carried a binder, each binder stacked with forms, logs, and checklists that governed the exact steps of a federal investigation. The law moved slowly, inexorably, and it always left a paper trail. Inside the regional office, the suspect's personal history began to surface. Background checks revealed patterns of grievance, online posts laced with hostility toward authority, neighbors, statements about prior incidents, and warnings that had been ignored or downplayed. Each fact layered onto the next, creating a composite portrait of someone who viewed society not as a set of rules but as an obstacle to his own assumptions. While the man had imagined a simple theft, quick, inconsequential, even justified, the system he had entangled himself with was anything but forgiving. The interview room hummed with fluorescent light, a sterile glow that seemed to magnify the tension between words and silence. Agents took turns speaking, asking questions with precision, circling the suspect with a rhythm almost surgical. He answered cautiously at first, then with increasing frustration, revealing impatience and disbelief. But the room itself had its own gravity. Walls lined with framed policy memoranda, the sound of distant typing, the occasional shuffle of paper, all were subtle reminders that the machinery of justice was watching, always calibrated to detect deception or intent. Across town, the judge sat in her chambers. She was not ruminating on fear, nor on anger, but on precedent. Years of adjudicating cases had taught her that moments like these were rarely about immediate resolution. They were about principle, about ensuring the integrity of the law when ordinary assumptions had failed. She reviewed her own notes, not as victim, but as guardian of the system she had dedicated her life to upholding. Every decision, every word, every action she took would be recorded, scrutinized, and evaluated against federal statute. Meanwhile, the suspect's initial confusion began to give way to panic. Calls to the local station had escalated into calls to supervisors. Case numbers were assigned. Forensic teams requested vehicle telemetry data, dash cams, traffic cameras, timestamps from cellular providers, all pieces of a puzzle that the man had never imagined existed. He realized too late that his actions had been documented from multiple angles, each frame a silent witness to intent, bias, and violation. Agents methodically reviewed his online footprint, forums, social media posts, comments laced with resentment patterns that revealed not just a propensity for risk, but an undercurrent of entitlement, a belief that the rules applied selectively to others. These findings were cross-referenced with his criminal history, minor infractions that had never escalated, warnings that had gone unheeded, encounters that had tested patience without consequence. The context was clear. The theft was not random. It was a logical extension of years of disregard. When the suspect finally faced the formal charges, there was a moment of disbelief. He had envisioned a minor confrontation, a scolding, perhaps a misdemeanor report. Instead, he was confronted with counts of federal vehicle theft, trespassing on government property, and aggravated bias-motivated intent, a combination that carried penalties far beyond his imagination. The agents were precise, professional, and unemotional, but the weight of their preparation pressed down on him like the law itself. And through it all, the judge observed quietly, a figure of composure and authority. She understood the necessity of procedural rigor, of measured escalation. She watched as the case transitioned from local to federal oversight, aware that the wheels she had once relied upon to enforce fairness were now turning in her favor, aligning justice with accountability. The irony was not lost on her. The very structure she had upheld for decades now protected her from the audacity of bias and assumption. As the day stretched into afternoon, the suspect sat in a holding area, his confidence unraveling. Under the weight of documentation, procedure, and the relentless logic of federal oversight, every step had been anticipated, every protocol followed, every legal protection invoked. What he had assumed would be a fleeting moment of dominance had instead become an escalating sequence of scrutiny, evidence accumulation. By evening, the preliminary charges had been formally filed. Federal prosecutors reviewed every piece of the case with exacting care. Telemetry logs, witness statements, surveillance footage, all of it painted a portrait of a man who had crossed a line he never saw. The chapter closes on a quiet but unmistakable note. The man was no longer in control. The law was, and it would follow its path with unwavering precision. The theft was no longer just a theft. It had become a lesson in authority, in procedure, and in the consequences of assumption. A small driveway in a quiet suburb had transformed into the first frame of a case that would ripple through the federal system. The courtroom was quiet before it began, but not empty. The air itself seemed to weigh on those inside, thick with the promise of scrutiny and the inevitability of judgment. Sunlight fell in slanted patterns across the polished wood benches, highlighting dust motes like fragments of the past, moments frozen for examination. Every step of the trial was choreographed with care, procedures observed, motions filed, and rules invoked with precision. The law, in its deliberate cadence, demanded patience, even from those whose lives were already unraveled. Court filings had arrived weeks before, each document a precise dissection of motive. Prosecutors labeled intent with surgical care, pointing to behavior, timing, and premeditation, while defense attorneys struggled to reframe the act as impulsive, inconsequential, a misjudged assumption. Each word on the page mattered, each sentence, carefully chosen, could tilt perception in subtle but decisive ways. Evidence was not merely displayed, it was curated, layered, and contextualized, a narrative told through data as much as dialogue. Screens flickered in the courtroom as body cam footage was played. The agents' voices were clipped, factual, devoid of emotion. Timestamps confirmed sequences with unerring accuracy. The moment he opened the driver's door, the hesitation before the engine started, the precise second the car left the driveway. Telemetry data from the vehicle corroborated the path it had taken. Speed fluctuation, steering inputs, braking points, all mechanical testaments to human choice. In isolation, these details might appear mundane. Together, they wove a tapestry of intent, undeniable and unflinching. From her vantage point, the judge observed the proceedings with a quiet authority. Years on the bench had taught her that power often manifests in subtle ways, through silence, through observation, through the restraint of measured speech. She did not flinch, did not react, but allowed the truth of the record to speak for itself. Her dignity was intact, unshaken by the audacity of the man who had assumed dominion over her property. She understood with acute clarity the difference between belief and proof, between perception and legal reality. The accused, seated at the defense table, began to sense the gravity of his situation. The confident arrogance he had carried through the driveway now met a wall of factual precision. The courtroom transcripts, combined with surveillance logs and digital records, highlighted contradictions in his narrative. Words typed in anger and bias, comments made online, messages sent to friends and acquaintances, were read aloud under oath, their implications more damning than any spoken threat. Silence in the courtroom became heavier than words. Each pause a mirror of the distance between intent and exoneration. Witnesses were called. Agents recounted their observations without embellishment, their statements precise and procedural. The prosecution framed each action, each hesitation, each misstep as part of a coherent pattern, a trajectory of premeditation rather than impulse. The defense struggled to contextualize, to argue mitigation, but the factual scaffolding surrounding the theft left little room for reinterpretation. In those hours, character was revealed not through confession, but through consequence. Actions, and the beliefs that fueled them, became evidence in their own right. Plea negotiations began in hushed rooms adjacent to the courtroom. Attorneys moved between tables, whispering the language of compromise, of reduced sentences, of minimization. The suspect had hoped for a path that would allow him to exit with minimal disruption. But each offer met an immovable wall of documentation, time-stamped evidence, video corroboration, and behavioral patterns that could not be mitigated by charm or argument. What he had thought was negotiable was, in truth, immutable. The weight of recorded truth bore down relentlessly. The judge's presence, though physically removed from the bargaining room, was felt like gravity. Her adherence to procedure, her calm observance, and the integrity of the law she represented formed an invisible scaffold around the prosecution's case. The accused confronted, perhaps for the first time, that reality was not flexible and that the assumptions he had acted upon were neither invisible nor inconsequential. His previous acts of bias, his dismissals of rules and warnings, now echoed through the room with legal resonance. The negotiation collapsed quietly, without theatrics. The plea that might have spared him a harsher fate dissolved under the unyielding weight of evidence. What remained was truth, as impartial and unforgiving as the law itself. The courtroom settled into tense silence, the gravity of consequence unspoken but universally understood. Every observer, every participant, felt the momentum of inevitability building, as if the very air had been compressed by the accumulated force of proof. In this chapter, character and consequence intertwined. Bias had become evident. Words once typed, spoken, or ignored now carried the weight of accountability. Actions had consequences far beyond intent, magnified by the machinery of law and by the clarity of recorded truth. The man who believed he could bend circumstance to his will now face the stark reality that law and ethics do not yield to arrogance. The final moments of the chapter leave him seated, disoriented, the gravity of his misjudgment closing in. Outside, the world continues: quiet streets, routine traffic, the hum of ordinary life. But inside, the collision between prejudice, choice, and consequence has irrevocably altered the trajectory of a man who underestimated both law and the woman it protects. The courtroom felt alive, though it was not moving. Every heartbeat seemed to echo against polished wood, every breath measured, as if the air itself had learned to hold its own. Sunlight filtered through the high windows, cutting lines across the floor in precise rectangles that moved imperceptibly as time passed. The trial had stretched over weeks, but now the final moment had arrived. An inevitable convergence of procedure, precedent, and human consequence. Jury members were seated, hands folded, faces composed. Yet each carried the weight of decision like an invisible load. The judge presiding over the case delivered instructions with deliberate care, each word enunciated slowly, as if carving clarity into the room. Statutes were cited, precedents were invoked. The language was formal, meticulous, but it contained within it an unspoken rhythm, law meeting fact, principle confronting bias. Silence punctuated every pause, allowing the gravity of their responsibility to settle in fully. The accused sat rigid, a man constricted by expectation and the mounting awareness of inevitability. His defense attorneys whispered softly, attempting reassurance, but the evidence, layered, precise, and uncompromising, had already done its work. Bodycam footage, forensic timelines, telemetry logs, eyewitness statements, and online records had left little room for ambiguity. The man had crossed a line, and the law now met him where he had faltered, unyielding and exacting. Outside, the world continued in oblivious rhythm, traffic, distant conversations, the hum of air conditioning. Inside, time had slowed. Every clerk, every officer, every observer felt the tense pull of decision. The jurors conferred silently, eyes meeting, nods subtle, fingers tapping rhythmically. Their deliberation was an unseen machinery. The weight of justice moved through them like a living current, imperceptible but undeniable. Finally, the foreperson rose. The room seemed to exhale collectively, an almost audible release. "We, the jury, find the defendant guilty." The words fell deliberately, measured, as if each syllable pressed into the floorboards themselves. There was no gasp, no sudden stir, only the slow absorption of reality. The verdict was not spectacle. It was inevitably the culmination of every calculated detail, every procedural step, every moral and legal principle invoked over the past weeks. The accused slumped slightly in his chair. His eyes darted to the judge, as if searching for reprieve in a place that offered none. The judge's own reaction was subtle, almost imperceptible, an unwavering stillness. There was no triumph, no overt satisfaction, only restraint, an embodiment of the dignity the law demanded, even when it had served justice so definitively. Her gaze met the accused's for a brief moment, steady, unflinching, a mirror reflecting consequence without emotion. Sentencing followed swiftly. Federal guidelines left minimal latitude when a crime involved the violation of government property, compounded by bias-motivated intent and premeditation. The judge recited the sentence with a rhythm that made each component tangible: life imprisonment for the accused, a $1 million fine to underscore the seriousness of the violation. The sound of the words lingered in the room, reverberating against wood and glass, embedding itself in the consciousness of all present. The courtroom settled into a quiet shock. It was a heavy silence, the kind that presses against ribs and shoulders without a single movement. Justice, when executed with full procedural integrity, does not roar. It descends. It is gravity, inescapable, immutable, absolute. Those seated in the gallery, reporters, clerks, attorneys, felt the weight collectively, an understanding that the law had arrived fully formed, uncompromised, and unflinching. The accused was escorted from the courtroom. His movements were mechanical, constrained by handcuffs, yet his mind raced, circling every decision that had led to this moment. Outside the courthouse, the world seemed untouched, indifferent. But the man who had underestimated both authority and consequence now moved into a reality shaped entirely by it. The judge remained seated for a moment longer, absorbing the silence, acknowledging the meticulous process that had brought them here. There was a quiet reflection: victory in law is rarely loud or celebratory. It is methodical. It is responsibility. It is accountability rendered in its purest form. The case would be cited, studied, remembered, not for the drama of the courtroom, but for the clarity of principle and the weight of consequence. As the room emptied slowly, sunlight continued its shift across the floor. Dust motes floated lazily in its beams, unchanging witnesses to a day that had altered lives irrevocably. Justice had been done not with emotion or spectacle, but with the quiet certainty of structure, procedure, and consequence. In that quiet, gravity remained, and with it, the indelible imprint of accountability. The courthouse had emptied, but the reverberations of the trial were far from over. In offices across federal agencies, policy memos circulated with urgent precision. Language was deliberate, procedural steps re-examined, checklists amended. Training protocols were updated not as a performative gesture, but as a systemic acknowledgement that one moment of bias could cascade into federal violation. The theft, once a driveway incident, had become a blueprint for prevention, a case study in vigilance and procedural integrity. Within internal briefings, the incident was discussed with measured intensity. Supervisors spoke quietly but firmly, dissecting the sequence of events, emphasizing the moments where assumptions had overridden observation. Agents reviewed bodycam protocols, communication logs, escalation procedures, aware now that even minor lapses could intersect with race, authority, and precedent in ways the system could not ignore. This was not about punishment alone. It was about adaptation, about ensuring that no future act of arrogance could bypass the frameworks designed to maintain fairness. Law schools added the case to curricula, not for sensationalism, but for instruction. Lectures parsed timelines, examined evidence, and highlighted the subtle interplay between intent, perception, and legal accountability. Students were shown how bias becomes tangible when recorded, how digital footprint and procedural documentation can serve as both shield and mirror. The story of a stolen car became a teaching tool, a warning that authority, when disregarded or underestimated, exacts consequences that ripple far beyond the initial moment. The judge returned to chambers with a heightened awareness of visibility. Her daily routines continued, but she carried an added weight, the consciousness of precedent, of scrutiny, of the symbolic resonance her experience had now acquired. Colleagues treated her with quiet respect, some with cautious curiosity. She had always embodied dignity, but now her presence carried the subtle reminder that even ordinary moments in ordinary places can intersect with the extraordinary reach of the law. Public attention remained muted but present. News reports documented the sentence, emphasizing the record-breaking fine, the life sentence, and the racial undertones of the case. Readers were drawn to the facts, the narrative of consequence, the unexpected collision of bias and law. Yet those who had been closest, the agents, the clerks, the prosecutors, the judge, understood that the real impact was not in headlines but in quiet recalibration. Procedures were amended, communications improved, oversight reinforced. The system absorbed the shock and adjusted, moving forward in ways imperceptible yet significant. The man sentenced to life imprisonment and fined $1 million began a new reality constrained by walls, routines, and regulations. Legal counsel, prison administrators, and federal oversight ensured that he would exist within a framework meticulously designed to limit autonomy. Each day would remind him of the divergence between assumption and consequence, belief and law, bias and justice. In offices, agencies, and classrooms, the case inspired reflection. Accountability reshapes institutions not through spectacle, but through accumulation, small adjustments, careful training, procedural diligence. The ripple effect of a single act of audacity extends beyond the individual, reaching into systems, practices, and policy. Justice, when it arrives, is not celebratory. It is methodical, exhausting, and precise. The judge, returning to her chambers one late evening, closed the door behind her. The hallway lights reflected faintly off the marble floors. She paused, taking a breath that was neither relief nor triumph, but acknowledgement. The system had moved. The offender was confined. The law had spoken, and yet the cost of vigilance, the weight of consequence, lingered in the quiet corners of her office, the exhaustion left behind by responsibility, the subtle tension of knowing that even a single moment can alter the course of institutions, precedent, and perception. Outside, the city moved on. Cars passed along the street she had once stood in, oblivious to the chain of events that had transformed a morning driveway into a federal case of national significance. Sunlight shifted across windows, dust motes drifted lazily through the beams, and somewhere, quietly, policy had changed, training had adapted, and law had enforced its immutable principles. Justice had arrived, not in applause, but in gravity. It left exhaustion where audacity had once thrived. It left the world measurably safer, procedurally wiser, and morally reminded that accountability, once set in motion, reshapes more than the individual, it reshapes the system itself.